Welcome. In this video, we'll break down what makes a contract valid in law. Whether you're signing a lease, buying property, or entering a business deal, understanding the basics of contract validity is essential. We'll explore the key requirements, formalities, certainty, possibility, and lawfulness. By the end, you'll know how to spot a valid contract and avoid common pitfalls. Let's start by setting the stage and understanding why these requirements matter in everyday life and business. Formalities are the rules about how a contract must be made. Most contracts don't need to be in writing, they can be verbal or even concluded by actions. For example, buying a snack at a shop is a valid contract, even if nothing is written down. However, some contracts do require specific formalities, like being in writing or signed. Understanding when formalities are needed helps you avoid entering into void agreements. Let's look at the different types of formalities you might encounter. There are three main types of formalities in contract law. First, some contracts must be written down and signed by the parties. Second, certain agreements require signatures in front of a notary public, who acts as a witness. Third, some contracts, especially those involving property, must be registered at the deeds office. These formalities are usually required for important transactions where the law wants to ensure clarity and prevent disputes. Knowing which type applies is crucial before you sign anything. Formalities may be required by law or agreed upon by the parties themselves. The law often requires formalities for contracts considered too important to be left to verbal agreement, such as marriage contracts, property transfers, and suretyship. Sometimes, parties choose to add their own formalities, like requiring all changes to be in writing. If these requirements aren't met, the contract may be void or unenforceable. Let's see how this works in practice with some examples. For a contract to be valid, it must be clear what each party has to do. Certainty of performance means the duties and obligations are either stated clearly or can be determined from the contract. If the terms are too vague or uncertain, the contract may be void. Courts try to interpret contracts to avoid uncertainty, but if it's impossible to know what's required, the contract won't stand. Let's look at how certainty is achieved and why it's so important. Imagine a contract that says, "I'll buy your car at a good price." That's too vague. What is a good price? But if the contract says, "I'll buy your car for $50, 0, or at a price determined by a third party," that's certain, or at least ascertainable. Courts can enforce contracts where the performance can be made certain, but not where it's left entirely open or subjective. Always check if the contract spells out what each side must do. A contract must be possible to perform at the time it's made. If it's objectively impossible, meaning no one could perform it, the contract is void. For example, renting out a donkey that had already died before the agreement is impossible. However, if only one party can't perform due to personal circumstances, that's subjective impossibility and doesn't make the contract void. This distinction is crucial in contract law. Contracts must be lawful to be enforceable. This means the agreement cannot involve anything illegal or against public policy. For instance, a contract to commit a crime is not enforceable. Lawfulness is assessed both by statute, laws passed by Parliament, and by common law, public policy and morals. If a contract is found to be unlawful, courts will refuse to enforce it, no matter what. Illegality can arise in two ways: statutory and common law. Statutory illegality happens when a contract is prohibited by legislation, like selling alcohol without a license. Common law illegality occurs when a contract goes against public policy, such as agreements that undermine justice or restrict freedom to marry. Courts interpret statutes to decide if a contract is void, and public policy evolves with society's values. Not every unfair contract is void. Courts generally enforce contracts, even if they seem one-sided. However, if a contract is extremely unfair, either in all cases or in a particular situation, it may be set aside as against public policy. Factors like unequal bargaining power or exploitation can influence the court's decision. Recent laws, like the Consumer Protection Act, also provide remedies for unfair terms. Restraint of trade clauses are common in employment and business sale contracts. They restrict someone from working in a competing business for a certain time or area. These clauses are generally valid, but only if they protect a legitimate interest, are reasonable between the parties, and don't harm the public interest. Courts may enforce only part of a restraint if it goes too far. Always consider if the restraint is fair and necessary. If a contract is void for illegality, neither party can enforce it. The ex turpi causa rule means courts won't help someone benefit from an illegal agreement. Sometimes, If one party is less guilty, courts may allow recovery to prevent unjust enrichment. To sum up, a valid contract must meet all requirements: proper formalities, certainty, possibility, and lawfulness. Understanding these principles helps you protect your rights and avoid costly mistakes. Thanks for watching. Stay informed and contract smart.